Good evening, good evening, good evening, everyone. I am so excited about my panelists tonight for this Plan, Prepare, Protect. And tonight, our topic is estate planning in the LGBTQ community. I think that's one of the most important topics that we can talk about. I got some really nice stats that I'd like to read to you all, and then we're going to go directly to our guests. The first legal same-sex marriage ceremony in the United States happened on February the 12th, 2004, when the mayor of San Francisco, Gavin Newsom, ordered City Hall to issue marriage licenses to same-sex couples. Same-sex marriage has been legally recognized in the state of Pennsylvania since May 20th, 2014, when a United States federal district court judge ruled that the Commonwealth 1996 statutory ban on recognizing same-sex marriage was unconstitutional. Okay. More than 60,000 Philadelphia residents identify as lesbian, gay, bisexual, transgender, and or queer. Philadelphia is the largest county in Pennsylvania to have changed the marriage license from bride and groom to applicant 1A and applicant 2B, as well as being the largest county in the state to stay open late as soon as the Commonwealth permitted same-sex marriages. So that is now a standard on our marriage licenses here in Philadelphia. My name is Tracey Gordon. I am the Registrar of Wills here in Philadelphia, Pennsylvania. We oversee the transfer of generational wealth, and we also issue marriage licenses and retain those marriage records in our archives. We are one of 67 counties offices in the state of Pennsylvania. We're the largest, we're considered first class. And we normally send the most amount of the state taxes to the state of Pennsylvania to the tune of $80 to $100 million every year goes to the state from the city of Philadelphia. We tie with, or go 1 and 2 with Montgomery County. And I think that's important for you all to know, because many times people think that, oh, Philadelphia is all violent, is all, even though it is one of the poorest, largest cities, but we actually do send a lot of money in the state taxes, and we all, our housing stock is really on the high end now. As you see, we're gentrifying. But tonight we're going to talk about estate planning and the LGBTQ community. And we have some distinguished guests here from Philadelphia. We have Selena Morrison. She's the Executive Director of the Office of the LGBTQ Affairs here in Philadelphia. We have Dr. Andre H. Ford. He's the Executive Administrator and Board Vice President, the Colors Organization. We have Sappho Fulton, who is the CEO of the Sappho and LaRoyce Foundation. He'll tell you more about that. And we have Thomas W. Udy Jr. Esquire. He's the Legal and Public Policy Director of the Mazzoni Center. I also have here with me my co-host and my solicitor here at the Registrar of Wills, Sharon Wilson. Let's go straight to the questions. I'd like to hear more from you than me. We're going to start this first question off. Let's go to Sappho. So given the ever-changing laws and court decisions covering gay marriage and related financial benefits, what else can the LGBTQ people do to protect their generational wealth?
Thank you, Registrar Tracey Gordon. I really appreciate you calling me first. There's a thing in our culture, like status quo, and I really didn't want to go first because
you can throw the ball. Listen, you can throw the ball.
It's all good. It's all good. So after carefully thinking about your question, initially when I saw your question, I'm Sappho Fulton, a CEO and Executive Director of Sappho and LaRoyce's Foundation. And what we do is we have a crisis intervention center. For those that don't know and that we haven't reached out to let you know yet, what we do is emergency response to domestic violence calls in the QT BIPOC community. We provide emergency housing for up to 72 hours. We go out in the street. We do a food service bank. Throughout COVID, we had to close down our center. At this point, what we're doing, what I have been doing lately, because we're starting to get those calls in again, especially from our trans community, is trying to help, like paying out of pocket, putting them in Airbnbs, trying to find rooming houses for them. So it's been a challenge across the board. However, there's a light at the end of the tunnel. We've partnered with Why Not Prosper, Dr. Reverend Michelle Simmons, and formerly incarcerated housing for women. So we have a component of that apartment building for long-term housing, especially specific for formerly incarcerated trans women.
Good.
So we're working on it. As far as the question goes, I've thought carefully about the question. Initially, when I looked at it, I was like, why is she asking me this? I don't know what the trans folks need in the Register of Wills. I can't answer that question. And then I thought about it a little bit more, and I was like, I think I can answer with an idea of what I think could work.
Okay.
So what I present to you and what I propose to you, Register of Wills, is that we create a, for the record, so we can share the legacy on this one. What I propose to you is that your office creates something like an archive for our trans community. One, our trans folks and oftentimes don't have what they see as valuable or valued assets, houses, family inheritance and things of that nature, what appears to a lot of us to be why we need a will. I would love to see the Register of Wills create a legacy fund, especially for the trans community of Philadelphia. That would be allowing them to write out, as you said, you can do this, write out with assistance of someone in your office, write out their will and how they would have it. If it's no more than just how they would have themselves being buried, the gender they want to present at, and maybe even asking the trans folks that are in a position to give, because there's some of us that, there's some of trans folks, I'm not sorry for saying us, there's some transgender folks, male and female, that are in a position where they can pay into an account. And maybe we can have a miscellaneous account at the Register of Wills where we can, because we talk about orphan fund, where we can have a fund for burial fund for those trans folks that come up and we don't know who their family members are. The other idea that I came up with was maybe giving some mock classes like this, continue to do these sessions to talk about like why we need a will, what life insurance looks like for us. Because when you're talking about housing disparities and persons that are destitute or in oppressed situations, the last thing they're thinking about is getting life insurance or writing a will.
Right.
I'm willing to partner with you in the near future. We can talk about this later. I just want to put it out there first. We can partner and talk about classes or maybe workshops on how to write a will, because you talked about it down City Hall, and I never heard that before, that you can write your will out, have it notarized, and put it in the envelope, and that could be your will.
Well, in the state of Pennsylvania, that can be admissible even without the notary. It's like a handwritten will with your signature. What we are doing here in our office is we have launched an education series, and I created an outreach team, and we go out into the community. So we want to make sure that now that we're connecting with you all, that you continue to be invited to some of and make sure all your your constituents go to our Facebook pages and our social media pages and like our pages so they can learn, because not just LGBTQ that are impoverished or working class, who are more likely not to have estate planning, but just some of them may inherit stuff because they are the birth, they are the birth, they have birthright inheritance rights. And then they need to understand their rights as well. And so, yes, I'm willing to partner with you all, just like I'm, partnering with other community organizations to teach people the importance of first understanding what the law, how the law governs and how you transfer your generational wealth. Because, although there are a lot of people that may be homeless or may not think they have their asset, your phone is your asset. That's your intellectual property. Your photographs is is also your assets. Any ideas, any books you have, your furniture, your clothes, assets come in many forms. Your children, You know, you may be taking care of sick parents. So assets is not just a house. And I think that's a great idea. I didn't think of that. And a lot of times we are so consumed with so many other things that we have forgotten about the business of estate planning. I want to ask and introduce Selena Morrison to us, and hopefully she'll be able to respond to that question and tell us a little bit more about what she's doing over in the LGBTQ affairs unit over with the mayor, and how, given the ever-changing laws and court decisions covering gay marriage and related financial benefits, what else can LGBTQ people do to protect their generational wealth?
You know, generally establishing a will to leave property and assets to the person or the people of choice can, you know, support protecting that generational wealth. Despite what those future court decisions that may affect gay marriage may be, creating a will allows us to designate our possessions to any person or entity. I mean, there are a number of resources available in our community, and many can be found, you know, listed online. I know the Community Legal Services website lists a lot of that. So yeah.
You know, now that it is legal to be married, that was one of the challenges the LGBTQ community had, because they didn't have the rights over, you know, making decisions over their partner that they lived for 30 years, 25 years. And I thought the fact that we have progressed as a country to allow same-sex marriages has, you know, really put us on another level. But at the same time, here in Philadelphia, we are now having problems with people not understanding the importance of, even when you do get married as a same sex, to make the will. That's one of the first things that couples should do. You know, once they get married, they think, you know, everything's automatic, but not necessarily, because that one partner may have had an asset and may have been married before, or that one partner may have children, minor children, and have had assets and gotten married again. And so all this stuff that, you know, people don't understand, that once they die, and some of the problems that happen when you don't make a will. I wanted to ask Attorney Thomas Udy Esquire, what did he feel about the LGBT community and some of the challenges they had with protecting their generational wealth?
Thank you, Registrar Gordon. So our program serves low-income LGBTQ folks. So a lot of the conversations we have with people about advanced planning are along the lines of what you were just talking about, and what a couple of people, Celina and Sappho, have both mentioned, which is that a lot of people think that they don't need, even people with substantial assets don't think they need to do any planning. The problem is, if you don't, then the person who is by default going to do it might have additional expenses associated with that, doesn't have any direction from you about what needs to happen or where things should go. There's just a lot of planning that can take place in advance. And that's with same gender couples. For a lot of folks within the trans community, trans and non-binary community, things can be included in a will and in medical advanced planning documents, addressing the name that someone should be addressed or referenced by, the pronouns that someone should be, that people should use when referring to them. A few years ago, there was an openly trans police officer who died, big part of the community, and had not left a will, and family members who were not supportive arranged for the funeral. So the arrangements did not include her name, did not include the correct pronouns to refer to her. And it was very upsetting to a lot of members of the community. These are things that I know you've got a question later on, I think, about what people may not think about, but that's one of the things that I would put in. And the other is that even with, and maybe because of, the fact that the laws are changing and people's lives are often much more complicated than people assume, updating these documents is really important as well. A couple may have been together for 20 years, but the way that the laws have changed, especially when it comes to marriage and other relationship recognition, the law may have changed so that the documents that were written before their marriage could be recognized may not reflect the fact that they either are married now or maybe they had a common law marriage. It was abolished in 2005, but there are couples who were together long before that who actually had exchanged vows. And you know, the more planning that they can do in advance, the better off everyone is going to be. And I think the last thing I would say about that is people don't like to call lawyers, right? People think of a lawyer as the last person they want to talk to or call, most people at least. But you know, we really can help. And the more lead time or the more planning in advance that people do, and the more consultation they have, the better prepared everyone can be, and the easier it'll be for everyone involved.
So Thomas, let's answer that question. Like, give us some of the issues that you see that the LGBTQ are not aware of as it relates to wills and estate planning.
So some of them are not unique to the LGBTQ community, but I think a lot of people don't think about the fact that if they don't have a will that says who's going to inherit or who gets to control what happens to their property, it goes by default to either a spouse or parents or siblings or other relatives. And even if someone may be on good terms with some of those folks, there may be someone that they're closer to who would understand better than a family member what those decisions should be or where they want their property to go. Writing it out is going to make sure that it goes in the direction that people want. A lot of us within the community are estranged from families of origin, may have a spouse that maybe the divorce didn't become final, but they've been separated for years. You know, there are ways to guard against the wrong person inheriting everything, but the best way is to do some planning in advance. And I'm glad you mentioned, you know, the holographic, you know, handwritten will, because that is one way if somebody doesn't have a chance to get somewhere. But that's, yeah. So the biggest things are put it in writing. And the other is make sure that the person who you've chosen to be your executor or make decisions for you is going to have access to the will after you've died. We get calls periodically from people who believe that someone left them property in a will, but the will is in that person's apartment or house and they don't have a way to get in. And the family members have already, you know, locked everything up or changed the locks. So make sure that when you've made those decisions, talk to the people that you're entrusting and make sure that they're going to have access to the information that they need.
Yeah, I see that quite often, not just with the LGBTQ community, but I see people be so heartbroken because they think a verbal will, like he said this was ours, or he said that this, when he died or she died, that this is my, or it automatically goes to me, and there's no automatic in the state of Pennsylvania. And I wanted to also let the LGBTQ community to know that what we're talking about tonight reference generalizing the state of planning, but you got to recognize the law that the state that you're going to, where your state is going to be raised. So in Pennsylvania, the laws are different from the laws that are in Maryland. And you know, you all need to know that, just in case, you know, if you move and you make your will or wherever your estate's going to be erased, you got to go by the laws that where you reside. I wanted to ask Dr. Ford this question. So there are LGBTQ couples out there who don't want to get married on paper, but still want to have a relationship recognized. Considering Pennsylvania no longer recognizes common law since 2005, and they don't recognize, and same-sex marriages are legal. What other options exist?
I always like to start out, I am not a lawyer.
Dr. Ford.
I am not a lawyer, but I have lawyer friends, and I tend to ask them a lot of questions. And to go into it, I got my first will done last year, and I've known that I needed to get a will accomplished for years. I've talked with friends, we've all talked about it, but never got my will printed out or set up until last year. And only reason I had I had to do it then is because I had open heart surgery. And I wanted to make sure I put on record where all my possessions will go. I have 3 sons. I wanted to make sure they receive my wealth. I put it like that. So, but to answer your question, creating a will helps to identify, in my opinion, I'll put it like that, helps to recognize that your partner, if you're not married, it helps to recognize your partner. A living will as well, because when you're in the hospital and you want your partner to be the one that helps to make the decisions on whether or not something may happen to you, I would say a living will is another option that says identify that person as the person you recognize to make the decisions for you. I can be wrong. I'm not going to sit here and say I'm right, and that's why I'm glad I know 2 lawyers are sitting here.
Yeah.
But that's my opinion. That's how I, when people ask me what I think, I tell them that, and so that's how I would handle those matters. But having a will helps to your property, especially your property, that you want to make sure that person gets it, but also recognizing a living will, which allows, especially in the hospital, that this person will make the decisions on your behalf.
Well, I'm glad that you said you made a will. And look, you made a will because you was having an open heart surgery. We're trying to get out to everyone to make a will when you get an asset.
Yes.
Whether you have an open heart, as soon as you get that asset, make a will. But Sharon, I wanted you to chime in on that question because I know you get that a lot in your practice. And
yes, hello everyone. What a very esteemed panel I'm finally able to join today. So I'm listening to this question about, I don't want my relationship necessarily to be formally recognized, but there may be a circumstance under which I want. But the short answer is, you really can't have it both ways. The law is encouraging citizens to bring formality to these relationships. Formality has its benefits, and it also has drawbacks for some folks. But if you will live in an informal way and you want formality at the time of death, you're going to find yourself working extra hard to prove that formal relationship really existed. And it gets harder and harder to prove things like we were common law or we were married once that person is gone. Because you can't assume that the people around you, think about this, if you want to hide that relationship, the people around you would be your potential witnesses who may also want to hide whatever that relationship is or however they came to be exposed to it. So if you decide that you don't want to formally get married or formally have that relationship recognized publicly, you could have a very hard time at the time of death.
Marriage is a business, I tell people. I know people, I say this all the time, when I do lectures and say, everybody wants to dressing up in the, the dinners, but it's a legal contract and it's business. And I tell couples, when, a lot of people still think there's common law marriage, and there's no longer common law marriage here in Philadelphia. And in the state of Pennsylvania, in the city of Philadelphia. And so you all have to be careful about, coming together in a partnership without considering the law of the land. I wanted to ask Sappho a question about the transgender individuals that face violence and discrimination and lack of access to essential resources and at rates far exceeding other members in our city here. So what can we do at the Registrar of Wills office to assist the transgender community?
Thank you for asking me that question. It makes me nervous to be a spokesperson for the trans community. I feel like, I don't have the answer? I'd like to think I did. I'd like to come up with this real fancy response and be like, oh, this is what we need. This is what it is. However, so I'm in school to be an international psychologist. So, and I'm studying LGBTQ/QT BIPOC issues internationally. And the same seems to grow across the board. There is, their personal trauma, there's mental health issues, there's a holistic approach that needs to happen. It's easy to say, let's address the housing component. Let's address, affordable housing. Then we put, a group of trans folks in these rooming houses or program houses or, Section 8 houses, and then they still have no developed mental health coping skills. They still have no ability to really even maintain employment here in the city of Philadelphia, because we haven't really set them up in that kind of way for success. So my answer to that is, I don't know. Let's have some focus groups and let's ask that community, let's ask our community what we need. What do you think you need aside from the immediate, the obvious? You need housing.
Right.
I had a situation, I'm gonna pause there, but that's an issue. Housing is a real issue, especially for the trans community. Let me say how critical it is. Okay, so since 2020, when the courts closed, they allowed the family courts to close and no one was able to access obtaining a restraining order. People were dying in houses at the cause of domestic violence cases. And we were looking at, what we've begun to do is look at, the crisis of gun violence. Domestic violence is a gun violence story untold, because now we have situations where we have, in 2021, last week, one incident happened and it's been ongoing with a trans man with a child. There's no place for him to go because he has an X on his ID. So if he calls the shelter system, he can't get in a women's shelter. He has an X on his ID. He can't get in a men's shelter. And then half the time they can't even get an answer on the hotline. So what do we need? There are a lot of moving parts here.
If you're being abused, you're not even thinking about estate planning. You're in trauma. Celeste, let me ask you this question. Celina, I'm sorry. What are some of the things that LGBT community people need to consider regarding end-of-life care and medical decisions? Because people always think that estate planning is thinking about the end of my life, but I look at estate planning as protecting your assets just in case your life ends prematurely.
Yeah, it's important for, not just trans folks, but LGBTQ plus individuals to look into those additional documents regarding end-of-life care or concerns, regarding any surviving children, any loose ends with property ownership, those things. Ultimately, it's important, for anyone, but especially the LGBTQ people who needs may be unique and may require some additional consideration to work with trusted financial and legal advisors like Thomas spoke about throughout the process of planning their estate. Now,
is that one of the questions on your applications? I mean, do you all have an application process when people come in to seek assistance? Is one of the questions on there, are you a homeowner? Do you all have that as a question on your intake?
We don't do end of life documents in my office for folks. We, not to say that folks don't contact us with that need, but that's something we do a lot of outsourcing and referrals to folks. Most of the time we refer those folks to Thomas.
Okay. The reason why I was asking, and Sharon can help me, because I normally ask all organizations when they do their intake, because I don't know if you've heard that we have like a severe Tangle title crisis here in the city of Philadelphia, most particularly in the poor and working class areas. And Tangle titles is when, people have some legal interest in a home, but the home is still in the dead person's name. And I was trying to incorporate, in your intake, questions like that, like, do you own a home? And when that would, if they say yes, they own a home, then the second question is the home in your name? And then from there we would, go into seeing if they need any assistance and understanding the importance of making wills, or understanding that they may be living in a home that they think they own, that their grandmother left to them or their grandfather left to them, but it's
Yeah.
still in the dead person's name. So they means they can't do anything legal with the home. They
Mhm.
can't get homeowners insurance. They can't sell the home. They can't pass the home down to their children. They can't get home equity loans so they can send their children to college. They can't get FEMA, which is government emergency assistance, because the house simply isn't in their name. And we have a lot of them and have identified the areas where these tangled titles are. And we wanted to make sure that we want to get the information, because a lot of LGBTQ people own homes or live in homes that may have been owned by their mothers and fathers that they think they inherited, but they don't realize that they're sitting in a home that they can't do anything legal with. And so that's some of the information that I would like to get out to your community, because we are in an epidemic, and there is a possibility they may end up losing those homes because those homes are not in their name. This is the map, guys. The map on your left is the 2021 total shooting victims by zip codes. On the right-hand side, the blue map shows where the highest concentration of tangled titles are concentrated in those same areas where there's a high incident of violence. And we just recently discovered that when these studies came out by the Pew Charitable Trust, and the other study was done by City Controller Rebecca Reinhardt.
Just a couple of things I want to say. One, while a will cannot help you necessarily, wills are very reliant and impacted by biology, but there are other assets that you may have, like real property. You can put anybody's name on a piece of real property that you want to. You don't have to have a formal married relationship. You can leave your interest in a business to anybody that you want to, without a formal relationship and without explanation as to why you did it. So I just wanted to put that out there. But I also want to say, in terms of the tangled titles and really the issue about homelessness that she was talking about,
yes,
we call tangled titles a piece of real property where the title of the property is in the name of a decedent. And we know that one of the things that impacts whether or not somebody leaves that property or changes the deed in that property to somebody else is the family dynamic that's in place during lifetime. So one of the things I would tell anybody is to be very realistic about how people think or feel about you during your lifetime. Death is not a magic pill. It doesn't make people all of a sudden treat you differently, respect you differently, think of you differently. So if you need to get your name on property, you need to work during the lifetime of folks to make sure that they have properly left things so that they will transfer to you. You need to, if you're in a position to, put your name on property or draft a will for yourself or for someone else so that those things will properly transfer. It's more important if you, particularly if the family dynamic isn't what you think it should be, to make sure that those things happen and that they happen in writing. We're trying to transfer property sometimes or to get property updated in a family dynamic where people might have just been neglectful, but there could be other issues at play. People might have been angry and disappointed. And when people feel like that, a lot of times they just do nothing. And doing nothing is what's causing a lot of people to be dispossessed of, assets that they may otherwise be entitled to. So already that homelessness is a problem. So to the extent that people are living and that people in the family have real estate as an asset, you really need to encourage people to start to have that conversation. People may not change how they feel about you, but sometimes as people get older, they do ease up a little bit in terms of what they're willing to do. So if you find willingness there, take advantage of that. And if it's not going to be there, then plan your estate like you will never have that thing, whatever that asset is.
Attorney Udi, you want to respond to that?
I can a little bit. I think it is incredibly important for anyone who owns property to be doing the planning and thinking these things through. And the Tangle title issue is a huge one in Philadelphia and some other cities, but really here probably more than a lot of others. But I also think it's important for people that don't own a home to be thinking about estate planning. I mean, everyone has an estate, everyone has an asset, right? And so I think that's one of the messages I'd like to see get through to more people is that someone is going to have to deal with their belongings after they've passed away, or even if they're in an extended care facility. And so the more they can think about who they want to take care of that, the less burden it'll be on someone who may not really feel equipped to do it or know what to be done and just may make their own decisions. So that's one thing that I think could be helpful. I think another is explaining things like we had talked about earlier. You know, if someone wants to make sure that regardless of what old records may turn up or other family members may say, this is the name that they should be recognized by, and these are the pronouns that they should be referred to with, and that's information that I think, you know, when we were talking earlier about things the community doesn't think of, that's one of the things that I think people don't know, that they can include that and have their wishes respected in ways that a lot of cisgender folks just take for granted. You know, I mean, my most complicated issue tends to be that I'm a junior, so there are forms where I don't know or they don't allow for that. That's minor compared with the type of issues that folks face when they're not respected.
When you draft documents, Thomas, do you actually encourage people to use the proper pronouns in the documents and any names that they may have had or changed in the course of their lifetime?
Pronouns for sure. We include a paragraph that addresses how someone should be recognized or respected. And as far as the name, it depends, at least in part, on whether they've had a legal name change. Even if someone has not had their name legally changed, they can still be clear that this is how they should be addressed and referred to. Not addressed, but referred to. And I think because there can be old records, it can be helpful to include information in a will that refers to previous names that someone may have used, particularly if they want to include a directive that that name should not be used when referring to them.
And they'll need that documentation because they'll have to prove that chain of title of that name at the time of death for a will to be probated.
Not necessarily if the will is in their current legal name. I think if someone has an old will and then has a name change, they need both documents. But the simpler way is to do an updated document, the same that you and probably a lot of attorneys recommend people do at any significant life event, right, is to update those documents. You should also do it if the people that you were originally listing as executor or decision maker for advanced personal planning, if those people are no longer available or in contact with you or maybe deceased themselves. So there's a number of reasons to update those records periodically.
But just keep in mind, Thomas, that sometimes we do wills to update names, but the original asset still carries the another name. So there still may be reason to make reference to that name. And you want to let your client know that you're not making reference to that other name because you don't respect their ability to be called by their present name. Sure. It's because legally you want to be assured that there's no confusion about, you know, the ownership of that asset.
Oh, correct. Thank you. Thank you for clarifying that. That is important because, we've had clients who have that situation where there's something that they've had for many years, and we don't want that to be left out of the plan, and want to make sure it's recognized.
So you're saying maybe formally known as, you know, that would be not disrespectful, correct?
So the will is not necessarily going to be referring to the person using more than one name, but it could list property as being
I guess.
in an earlier name or in a different name.
So Thomas, could you give some few examples to for us as far as assets other than a house?
Clothes, furniture, television, appliance, maybe not appliances. I'm thinking of people that, rent rather than own a home. But, everyone has some things. They may have jewelry or personal
Their
items
cell phone.
that have sentimental, sorry?
Their cell phone with all
Right.
their information, their
Cell phone.
pictures. They might want all their accounts shut down, or they
Right.
don't want nobody to get their phone. What's
Or
some
they
other
may
things?
they want to make sure that someone gets those pictures, or that some people get those pictures. And without doing some advanced planning, it essentially throws it in the lap of someone else, and they've got to then try to figure out what to do. It's also helpful if there is a cell phone or for other accounts, have some reference that someone can look at that'll have login information, passwords, that kind of information, all the things that IT people tell you not to write down. It really could be helpful to have that written down for someone.
Yes.
I think that'll be important, like writing down the PIN numbers on a document though, Thomas, because their information maybe about their dead name could be inside of their phone, and they could keep that information to go onto their will. One is I got several questions coming in on my phone that I'd like to present to you before we finish. And two is that I notice now that when I go to my primary care, I'm just putting it out there, that they always ask me, do I have a living will? Do I have a will? Do I have a living will? So it can't be a hard transition or a hard adjustment or amendment to our intake packages. It just has to be, I think we just have to add it in there. So I think that's a great point. I just wanted to bring that up before I forgot it. Yeah.
It is a
Getting people to-
distinction between a living will and a will.
And then the next step is, if they say no, then getting them to do something about it, right? That's the next step, because people will check
Exactly.
that off, but it doesn't mean they're necessarily ready to take that next step.
Yeah, and that's where we come in at, because we have plenty of literature that you can.
I want to add, because it took me years to accept that I own a lot of stuff, and you go, what do I have? What do I own? Things that we find to be of no value to us because it's our possession may be of value to others. And I'm an art collector. I've been around the world and collected paintings and pictures that are throughout my house, and to watch my family. I go to see my sisters and my siblings and my parents, and I'm over their house. That's mine. That's my picture. And they go, you gave it to me. You told me I can keep it. And so those are the things that made me go, I have to identify my stuff.
Yes.
And say who gets my stuff, because I really found out that if something happens to me, they will fight my kids tooth and nail for my stuff. And it had to be, sit down, let's say, this is where it goes. And so the lawyers are correct. This is little things that we find.
Not only this is where it goes, but this is who I want to be my executor. And this is where I'm leaving it. It's people we hear hearings all the time. People say, I know my mother or my father had a will. We can't find it. Mm-hmm. That means they don't have a will. If you have a will and you don't let someone know where that will is, and you are right about your possessions. And you're saying your family will fight. Your children will fight. What you did, I'm not saying your children personally, but I'm just saying that I have experience and I see lots of children fighting because there was no will left and there was no executor left. When simply, if you make the will, you name your executor, we have to follow what you want us to do, because no one is teaching us that. They're not teaching it in school. They're not, and I'm talking about primary school, I'm talking about secondary, high, and I'm talking about college. They're not teaching that. They're not teaching that when you buy your house. That's what I want to start, getting some legislation passed that when you buy a house, when there's a transfer title, that some information should be given about estate planning. I think that it has to become a conversation, and that's why we're having you here, because you all need to start having this conversation, especially now since, same-sex marriage is legal now. So it's a different dynamic when you're married, but there are components that can go wrong if you've been married before and you had the house before you got married to the next person. So we always say consult attorney. Attorney Uday, I wanted to ask you another question. We're finding that LGBTQ community are at higher risk of having their wills contested and challenged by others unsatisfied with their decisions. Now, you talked about that earlier. What can they do to better prepare themselves?
So I don't know that it's possible to prevent someone from coming forward and challenging it, right? But first of all, having the documents and having a will that spells out someone's intentions is one way to do it. I've heard different people have different viewpoints on whether it's helpful to specifically name someone you want to exclude. I think it certainly makes one's intentions clear by doing that. I think the first thing is to make sure that the documents are in place, and that not just the person who you want to be the executor, but maybe the alternate and maybe some other folks know where that is so they can get to it first. Because if a family member who would be the person to inherit by default or the executor by default, if they get their hands on that will first, then all bets are off on whether that turns up. It might not even exist for very long if they're not happy with what they see. I think the most important thing really is do the planning. There's a question that came in through the chat about where someone should store a will. I think it needs to be in a safe place, but not a place that nobody can get to. So not a safe deposit box, and let the people that you trust know where that is. Make sure you can trust them. I think to Sharon, I think to your point earlier, know that you can trust these people. So you want to be sure of that, but which is one reason to have more than one person, perhaps, that you are letting know about this. But I think that, putting it in writing, and I think it can be explicit. If things have been distant for a long time, then you're not going to be creating new issues. You're just going to be making sure that someone doesn't get past the decisions that had been made, or the whatever friction there was existed long ago.
And I would only add that I agree with everything that he just said, but I would also add that if you're able, because we do have services that provide free legal services for wills, get an attorney to draft your will. When you're in a will contest, you don't want that scribbled up will that you wrote at your desk, and magic marker saying, this is my will. It's going to make it harder for you. This is the time where you need a will prepared by a professional.
Yes.
Where witnesses aren't an issue, where the format isn't an issue. So that is one of the things you can do. The other thing is, and the reason why we talk about estate planning is not just your will. Sometimes when courts and other bodies are trying to determine whether or not this will is authentic, they often look at the other documents you have drafted. So if you have that living will that we talked about earlier, and it gives the same person the right to make those kinds of medical decisions for you, and then you have a power of attorney, and it gives the same person the right to make those other kinds of financial decisions for you, it won't be a stretch to say that you would then leave that person in your will to some extent. So if you have an estate planning sort of history and other documents that support the will, that would also be helpful to you at the time of a contest. And they ask, can you write, what one of the questions in the chat say, well, will a will be strong if there's no formal marriage? Yes, if you take the time to do the things that we just talked about, you can make that document, you can strengthen that document against people who want to contest. And like Thomas said, we can't keep people from contesting. We can just do what we can to keep them from winning.
Just make
I have a
sure
question.
you consult, with an attorney and make sure that will is bulletproof. Sappho, you said you had a few questions for our attorneys.
Two.
Okay.
They lost their partner of 30 years in May. There was no written or executed executive named. I need to know what information do I need in order to set up an estate account, and how do I get an appointment with the Register of Wills office? I hope these are intelligent questions, as this is above my pay grade. I didn't read it before I read it out loud.
Sharon, you can take that
All right.
question.
Okay. We would both probably say the same thing. When there's no executor named, I assume that's because there's been no will drafted. And when there's no will drafted, you're in a state of what we call intestacy. And the law then makes the decision about who is eligible in the pool of people to become the executor. And they look at biology first. So if the person that wrote that wants to be the administrator, if they want to be the administrator of that estate, and there is no biology, there's no formal marriage, and there's no family relation, then they will have to give notice to all of the other people who would come before them biologically. And if they agree and don't object, then they would be able to make an appointment going forward and becoming the administrator. And that agreement has to be in writing.
Because the person mentioned that they've been together, they were partners for 30 years.
30 years.
So common law marriage was abolished on January 1st of 2005, but common law marriages that were entered into prior to that are still valid. And there are same gender couples that have been able to, and widows of same gender couples that have been able to prove that. I wouldn't be able to speculate on what this person would be. And it's difficult to prove. I think Sharon's points are correct. It's really difficult without something in writing. But talking to a lawyer who can sort of help assess the individual circumstances would probably be helpful.
While you may be able to prove it, currently the written law says that they don't recognize same-sex marriages in a common law environment, but they have had some success in sort of chipping away at that. But as he said, it's very difficult, but it can be done. It was done for at least one person in one case that I read.
Good. Thank you. The second question is, my wife and I separated. I have assets, but I also have children. Will she automatically get my assets, or do they automatically go to my children? And thank you for doing this show.
They're welcome. You're welcome. But it'll depend upon how the assets are titled, because some assets can pass from spouse to spouse. And it will depend on whether or not who is listed as the biological parents of those children. Biology still plays a part with children unless you specifically make a writing to the contrary. So, in other words, in Pennsylvania, children who have the same parents, in other words, the same father and the same mother, if there's no will, are treated differently than children who have the same mother but not the same father, or the same father but not the same mother. So it's not as easy an issue as you might think. We might have to delve a little bit deeper to see what parental arrangements were made regarding those children. Since you deal with this more than I do, Thomas, feel free to join in, but that's what I recollect for right now.
Yeah, so we don't, because we work with low-income folks, if there are assets, we usually say that they should talk to a lawyer who can handle and talk to them about that. And yeah, with parenting, it can be complicated. There may be an adoption, or there may be other ways to prove parenting, but a trial to prove parentage rather is time-consuming and complicated. So again, this is one where it can be helpful to talk to a lawyer earlier rather than putting off that call.
We're closing out on the show. This was great. Sappho, you want to tell us some things that you're doing over there?
So there's a couple things coming up. There's a discussion on in the QT BIPOC community around issues of domestic violence. We're challenging no. Let me be careful about my words. We're having conversation with state reps, and you're welcome to come and table and present as well. But we're having conversation with the city about, best practice and next steps in terms of domestic violence in our community. The second thing is on the 24th, we have Our Survive, which I'm working with Movita Johnson Harrell, and the flyers will be on my page. I tried to put them in the link here, but I will.
We'll put them up on our page as well.
I appreciate it. Thank you.
Dr. Ford?
The Colors organization is by continuing our effort to understand what matters to our community and to assure culturally relevant communications. We launched the Conversation at Colors. It's a social media platform-based initiative in a talk show format that creates a safe place for LGBTQ people to identify and speak their truth. It's on YouTube, and it's called the Colors Organization 21. We launched this opportunity in July, and it's been going on. We put a new episode up every other week. Please look at it, learn things. The first episode was with 5 trans women to talk about trans women experiences. And it was our biggest event, the biggest one that went out. So
really,
we've been doing it since July. Look at it. If you like it, hit like. If you want to subscribe so you can see other ones, please subscribe. We have an episode coming out next Friday talking about the barriers of straight and gay people.
Attorney Ukte?
So Mazzoni Center is a comprehensive health and wellness center that provides a range of different services from primary care, behavioral health, education, HIV prevention and education, and then legal services is a part of it. Some of the programs serve everyone. It's an LGBTQ affirming environment that affirms the dignity of and well-being of the people that we serve. Legal services, we do target our services to LGBTQ folks. Name changes has consistently been the #1 issue that people contact us about. It's not necessarily more than half of the work that we do because other things can be more time consuming. We also work with people on discrimination claims, advanced planning, adoption, other types of family law. So including we've helped people get divorced from relationships that they'd entered into that for a long time they were not able to. So a whole range of different issues.
Celina?
In addition to our many outward-facing panel discussions, presentations, workshops, all of those things, we recently dedicated the first historical marker NPA to Gloria Casares for her amazing work. Gloria was the first executive director of LGBT affairs and was appointed by Mayor Nutter. Internally, there had been no measures of the identities of the city workforce. So to ensure that the city's workforce is representative of the communities that we serve, we just created a platform that is titled the Employee Self-Identification Census, where city employees can self-identify their sexual orientation and gender identity. Also, we're about ready to launch some more internal work that is really some guidance for transitioning employees. And that's guidance for the employee and also for the supervisors and managers that will be working with these employees.
That's great, great. Thank you all. And Sharon, do you want to give some closing words to our I always get an LGBTQ community?
Well, register, they just changed the acronyms. LGBTQIAP plus /QT.
I didn't even want to try it.
LGBTQIAP plus QT BIPOC. You got it.
Oh my God, I did not want to.
I tell anybody, if you know you have a complicated situation in your life, and sometimes sexuality does complicate your life, plan for it. That's all. Make a will.
Make
Don't
a
wait for a
will.
heart attack. Make a will.
Make a will.